Can arson lead to a murder charge in NJ? Arson in New Jersey can lead to a murder charge even when there was no intent to kill. Under NJSA 2C 113A 3, a death that occurs during the commission of arson can result in a felony murder charge if the person who dies was not a participant in the crime. That rule can apply when the victim is a building occupant, a bystander, or a firefighter responding to the fire. New Jersey does not require proof that the accused planned or expected a fatal outcome for felony murder to apply in an arson case. Arson becomes a predicate offense for felony murder when a non-participant dies during the fire or during immediate flight from the scene. A person who sets fire to a commercial building for insurance money can still face felony murder charges if a firefighter dies responding to the blaze. The mental state behind the fire affects whether prosecutors pursue murder, aggravated manslaughter, or reckless manslaughter. A murder charge under NJSA 2C 11 the 3rd of May apply if prosecutors claim the fire was set purposely or knowingly to cause death or serious bodily injury. A person acts purposely when causing death is the specific goal. A person acts knowingly when aware that death or serious bodily injury is practically certain to result. Setting fire to an occupied building while knowing people are inside may support a knowing murder charge. Reckless manslaughter under NJSA 2C 114B 1 is a second-degree crime that applies when someone consciously disregards a substantial and unjustifiable risk of death. Aggravated manslaughter under NJSA 2C 114A 1 is a first-degree crime that applies when reckless conduct shows extreme indifference to human life. Arson in New Jersey includes more than simply starting a fire because the charge depends on intent and the danger created. Even burning your own property can lead to charges if the fire endangers others or is connected to insurance fraud. Aggravated arson is a second-degree crime under NJSA 2C 17(1)A when a person purposely or knowingly places another person in danger, destroys another person's structure, or seeks insurance proceeds while recklessly endangering others. Simple arson is a third-degree crime under NJSA 2C 17(1)B when a person purposely starts a fire that recklessly places someone or property in danger. The type of property matters because fires involving occupied structures such as apartment buildings, schools, or places of worship are treated more seriously. Common motives behind arson charges include insurance fraud, retaliation, concealing another crime, and reckless behavior involving fireworks or open flames near flammable materials. Penalties can range from 3 to 5 years for simple arson to 30 years to life for felony murder based on arson, along with substantial fines. The No Early Release Act can apply to aggravated arson involving danger to another person, requiring service of 85% of the sentence before parole eligibility. A conviction can also lead to long-term consequences involving housing, employment, firearm rights, and possible civil claims by a victim's family. A defense lawyer may challenge whether the fire was intentionally set, whether the death was sufficiently connected to the fire, or whether the accused was involved at all. Faulty wiring, malfunctioning appliances, improperly stored chemicals, alibi evidence, and mistaken identity may all become important issues in the case. A criminal defense attorney may also raise the limited statutory defense available in some multi-participant felony murder cases under NJSA 2C 113A 3. For guidance on these charges, contact Lustberg Law Offices, LLC, a law firm at 1 University Plaza Drive number 212, Hackensack, New Jersey, 07601, United States, or call 201-880-5311 to speak with a lawyer or attorney about your case.